welcome to the latest in free series of coronavirus related webinars. I'm Jessica Brickley, one of the professional support lawyers here at Freets, and I'm joined today by Pearson and Kirstin Roberts, who are a partner and director respectively in our commercial team. Today's title is How to Manage Your Contracts in the New Normal, and we're going to be looking at a few recent developments that impact your commercial contracts, as well as giving you some of our sort of practical thoughts around how you can manage your contracts. Before we start, I should draw your attention to the Q&A box, which you should find in your Zoom toolbar. If you'd like to ask any questions during the session, please do drop them into the Q&A box. You can ask them anonymously, or you can put your name, up to you, and we'll answer as many questions as we can during the session. If there are questions we don't have the chance to answer today, we'll be coming back to you directly on those afterwards. Okay, so we're going to start off looking at the Corporate Insolvency and Governance Bill. So this is something which came into Parliament on the 20th of May and was actually debated in the House of Lords yesterday. So they agreed a series of amendments. It's now going to return to the House of Commons. So the government's original intention was that this would become law sometime in late June, early July. That may have been a bit optimistic, but there certainly still seems to be a will to bring this into law as soon as possible. From a quick look at the Lord's transcript this morning, there doesn't seem to be any significant changes that are going to bear on the aspects I'm going to be talking about. But just bear in mind as I go through this that the legislation may still change before it comes into law. So there's a variety of implications in the bill. It runs to over 200 pages. There's implications for various areas of insolvency, but there are really three key aspects when it comes to managing commercial contracts. I'm going to be talking primarily about the moratorium regime and also the effect on clauses that allow termination of a contract for reason of a party's insolvency. But it's worth also bearing in mind that there is temporary restrictions on statutory demands and winding up petitions being brought in. And winding up petitions obviously often a weapon in the struggle to recover payments. So it's worth having that in mind. But mainly I'm going to cover that first and third point on the slide. So we'll start with the moratorium. Now, the idea here is that companies will be able to apply for a moratorium period, which gives them protection from creditors. So, and that's under the supervision of what's called a monitor, and that's effectively an insolvency practitioner, much as you would have if you were in an administration or something similar. So this is for an initial period of 20 business days, but it can be extended. The company in moratorium can apply for extensions. And the moratorium does exclude certain types of companies. So that's primarily things like financial services related businesses, such as banks and payment providers. They can't use the moratorium. And also public-private partnership project companies. But other than that, so this is a facility that's available to any company out there that needs this period of protection. So what the period does is it provides what's described as a payment holiday. And this is both for pre-moratorium debts and also debts falling due during the moratorium period. There is a collection of exceptions included in that. So things like, well, firstly, payment for goods and services that are supplied during the moratorium period, those still need to be paid for. And also any wages or salary owed. There's obviously that kind of extra protection for the employees. And the way the payment holiday works is it places a cap on what the business in moratorium can pay out on its debts. The cap is set at either £5,000 or 1% of the total unsecured debts of the business when it went into moratorium, whichever of those figures is higher. Now, they can still make payments of debts if they've got their monitor's consent, so that in an insolvency practitioner, but the monitor will only allow to be given consent if it will support the rescue of the company as a going concern. So they will only give consent in those circumstances. There is also going to then be the ability to obtain court orders to pay debts. If you're the subject of a court order, then you still have to pay those. And also things around payment of proceeds of sale out of security. So if you've sold a mortgaged property and you need to pay off the mortgage, those kind of things. So in addition to that general restriction on paying debts, a company in moratorium can't have enforcement of security over its property take place. That then also the same around repossession of goods, And there's also a restriction on legal processes being instituted, carried out, or continued against the company. So, and there are, again, exemptions around things like employment tribunal proceedings and employment-related legal processes. So again, it's protecting the employees of the companies. But overall, you won't be able to take legal action against a company that's in moratorium. And this is really why I bring this up in the kind of management of contracts context, because all of this underlines the need to be even more on top of your management of contracting parties. And Kirstin's going to cover that in a bit more detail later. But it really underlines that importance of making sure that you are keeping on top of your debts. Because if a company suddenly picks up that this goes into moratorium, then you're going to be much more limited in what you can do during, and obviously it's a limited period, but you will be limited in what you can do during that period. Okay, so that's the moratorium in brief. There's obviously a lot more to it, but I think that's the key things that you need to have in mind. Now, the other aspect that I wanted to mention out of the Corporate Insolvency and Governance Bill is the effects that it's going to have on provisions in your contract that allow you to terminate contracts for the insolvency of the other party. So this is a common provision in most commercial contracts. I'd be surprised to see more than a handful really that didn't have this kind of provision in there. Now, there are existing rules, there's existing legislation that prevents supply of essential goods and services being terminated because a business has become insolvent, but that really is limited to things like utilities and communication services. So this rule extends that to the supply of all goods and services. If you're a supplier of any kind, then you're going to be restricted from using termination provisions that allow you to terminate when your customers become insolvent. So it is worth saying there's a small supplier exclusion in here. That refers to if you're a supplier that has either, so you need at least two of these three things: a turnover of no more than 10.2 million in your most recent financial year, a balance sheet total of no more than 5.1 million in your most recent financial year, or no more than 50 employees averaged over the year. So if you fall below two of those thresholds, then this isn't a problem for you. But if you don't, then this obviously then becomes, again, like the moratorium issue more generally, it will restrict what you can do in terms of contracting counterparties, specifically customers that become insolvent. And this rule applies where a company enters that new moratorium period, as well as the usual insolvency procedures like administration, administrative receivership, liquidation, all those kind of things. So what does this actually do? Well, so there are three effects really that I think it's worth having in mind. So firstly, if there are any provisions in your contract that either automatically terminates contract or supply, so not necessarily the whole contract, but enables you to stop supplying, or does anything else, or entitles you as a supplier to do any of those things, to terminate the contract or supply, or entitles you to do anything as a result of the customer's insolvency. So because the customer's become insolvent, you won't be able to exercise that provision during their insolvency. So there is also then a provision that says if you had any entitlement to terminate for any reason that arose before insolvency, and you just waited and didn't exercise it, you can't exercise it during insolvency or moratorium period. So those are certainly very heavily restricting when you can use these types of rights. And then there's a third limb to this, which sort of it's sort of meeting a bit of a loophole, I suppose, in that it says that you cannot make it a condition of continuing to supply a business during insolvency that they pay you everything they already owe you. Now that's, again, it's a common tool that businesses use to protect themselves in the event that their customers have become insolvent. So that's potentially got quite a significant impact as well. However, there is a little glimmer of hope here. You can still terminate under an insolvency related provision if the office holder consents, so in an administration, an administrative receivership, a liquidation, something like that, if the administrator or the liquidator consents to the termination. or in other forms of insolvency or in moratorium, if the company itself in the insolvency or moratorium consents to termination, or if the court grants permission. However, the court will only grant permission for termination under these types of provisions if continuation of the contract would cause the supplier hardship. Now, again, that's one of those things where we don't really know what that's going to mean yet. And so there's going to be very much a watch this space in terms of what does hardship actually mean, how much hardship does there need to be before the court will grant permission, and obviously are people really going to spend money going to court to get those kind of orders? We'll just have to see on that. So again, this underlines the need to keep on top of your contracting relationships, make sure you're doing adequate due diligence, and keeping aware of your customers and suppliers' financial positions so you don't get caught out when one of these events happens to one of your contracting counterparties. Okay, so before I move on, I've just got one question in the Q&A at the moment, which I'll just pick up quickly. And someone's asking, what can I do if I have to keep supplying a customer who's gone into insolvency, but they aren't paying their bills? And it's a good question. Obviously, you've got quite a lot of restrictions here. But it's important to note that these provisions around termination for insolvency, they're specifically around termination that is because of that insolvency. So if you've got another right to terminate, so let's say someone hasn't been paying their bills during the moratorium period, then you can still use other rights to terminate, such as termination for material breach, or you may have termination for non-payment of bills. It depends what your contract has, but there's certainly going to still be scope for you to exercise those other termination rights, albeit still bearing in mind that that's those other rules around what debts can and can't be paid during a moratorium. But if you've got, say, you've been supplying during the moratorium period, and you're entitled to terminate under your contract for material breach, then the termination for insolvency provision doesn't wipe that out. So hopefully that's giving you a bit of reassurance. I'm now going to pass on to Stephen Pearson, who is going to talk to us about well, I'll leave Stephen to tell us the name of it. It's a bit of a mouthful. Over to you, Stephen.
Okay, thanks very much. Yeah, I'm going to be talking really about two things. Firstly, the guidance on responsible contracting behaviour, but also I'm going to touch on the force majeure and one or two consumer contracts issues. Firstly, the mouthful, the guidance on responsible contracting behaviour issued by the Cabinet Office. Could I have the next screen, please, Jess? Really, just to state, this is one of a number of documents issued by the Cabinet Office. It is an advice document, it's a guidance document, so it doesn't have full legal effect. But I think it could be useful if you are seeking to argue the position perhaps with a supplier or a customer that we're all supposed to be following government guidance. It was issued on the 7th of May. And it follows some advice that's been given to public sector bodies that I might touch on later if I have time. Firstly, it relates to both the public and the private sector. It's very clear the government is encouraging all individuals, businesses, including funders and public authorities, to act responsibly and fairly in the national interest. The mention of funders is, I think, quite interesting. Obviously, a lot of organisations are probably technically in breach of their banking covenants at the moment, and it's saying, please, we want trade to carry on, we want contractual performance to carry on. Some of the provisions within the document, it's quite small, and it's only 4 pages, so it's worth a read, is to be responsible and fair in terms of your dealings. That's a little bit vague, but for example, what's meant by that is to give relief. So where there is contractual performance that isn't quite being met, it should just give relief for that impaired performance. Don't be too strict about enforcing key performance indicators, penalising people that are slightly late in terms of delivery dates and that sort of thing. And clearly, a number of sectors are having problems meeting delivery dates because of things like factory close down, social distancing, etc., etc. To allow extensions of time, it's just, for example, that you might want to allow a substitute or alternative performance, or even allow compensation for increased cost if you're trying to get additional performance out of people. The return of deposits probably something that's quite topical, particularly in say, the travel sector. It's stating that people should seek to return deposits or part payments. So the traditional arrangement with a lot of suppliers to say that if you don't go ahead with a project with an order, then you have lost your right to reclaim the deposit back. They're saying that shouldn't really be imposed too strictly. And also seeking to resolve disputes. I think there's clearly a concern that once we're over all this, there's going to be lots of work for litigation lawyers. This is really saying that people should seek to resolve disputes amicably, use alternative dispute resolution, mentions, for example, the RICS that have a model adjudication procedure. Also, the Construction Leadership Council are apparently involved in issuing further guidance about how construction disputes might be resolved, traditionally a very disputatious area. So generally, you know, lots of good things. It is only guidance, but I say we have been saying to clients, well, you ought to refer to this in the case of your dispute, and perhaps shame people on the moral ground that they really ought to act in accordance with the guidance and not be too strict in terms of enforcing the contract. Also, for public sector bodies, I think there are a few within the audience, as they may be aware, there are a number of specific bits of public sector guidance, and there's Cabinet Office Purchasing Policy Notes 01, 02 and 0420. 04, which is issued a week and a half ago, and that's really talking about how people should work with suppliers to recover and transition from COVID-19. That's suggesting things like, you know, working partnership to develop a transition plan, pay people as quickly as possible. Cash flow is going to be an issue. Terminate contracts if you need to, but seek to do that in a fair and reasonable way and not be too strict in terms of contract requirements. So next slide, please. Just going to touch on an issue that we have been seeing quite a lot of in the commercial department, which is how does my contract cover the outbreak? Traditionally, people are aware, I think, of something called force majeure. That's something which allows people not to perform a contract where they are prevented by circumstances beyond their control. Typically, that covers things like, for example, serious weather conditions, industrial disputes, strikes, dock strikes, but very, very rarely in our experience, pandemics. It's very usual to see a force majeure clause covering pandemics in any degree of detail. So, you know, that is likely to be a problem. The other issue to bear in mind is that people assume that force majeure always applies to contracts. No, it doesn't. Unless a clause is written within the contracts, you don't have cover in terms of force majeure preventing you from performing the contract. So what do you do? In certain circumstances, there are actually provisions within the contract that allow for what's called a specific change in law. We see this in some major supply contracts in things like the leisure and waste sectors, which says that where there's a change in law and you have a cost to comply with that change in law, then you can claim compensation for the people that are employing you under that contract. And those 2020 regulations actually contain a list of various establishments, various buildings that can't open during the period of lockdown. Examples include things like leisure facilities, swimming pools, leisure centres, playgrounds, and that sort of thing. Now, in that circumstance, if you are put to additional cost or you suffer losses, you may be able to claim from the people that are employing you because you're complying with that legal restriction that applies to your setup by name and not to the world as a whole. So just worth looking at particular contracts. And what about the recovery phase? The difficulty that a number of people have said to us is that there's one thing having lockdown. After lockdown, which may be obviously from week after next, if you're running a pub or a restaurant, trade is not going to be the same as normal. Can we claim compensation for that? The answer is unfortunately probably not. The situation of force majeure or the change in law will probably end, technically speaking, at the point that the law clicks back and the regulations are rescinded. So you may have difficulty. That's something that you might have to negotiate with the people that you're working with on contracts. Next slide, please. Yes. So if you do have force majeure clauses in your contracts, how should they be amended? Slightly locking the stable door after the horse has bolted, but who knows, there might be a second spike. So if you are looking at writing contracts, working with lawyers on contracts, do please ensure that you refer to epidemics and pandemics and actions taken by the government in connection with it, and say that is force majeure. That entitles you to suspend performance of the contract, potentially to claim compensation, potentially to terminate. Consider broadening the effect of force majeure, so not only where performance of the contract has been prevented or where it's been hindered or made more onerous. So if you can reopen your service, but you've got to preserve social distancing, you can't have the same amount of customers, you're running a cinema, theatre, something like that, allow for that potentially and make it part of the contract, because unless you do, it's probably not covered. Consider broadening the range of consequences. For example, a lot of businesses are concentrating on core business and not doing parts of their service, not making certain products. So say that you are permitted to cancel orders, to postpone fulfillment, suspend obligations, or even terminate, and allow for that within contract. And consider providing clarity as to the effect on payment obligations. For example, and this is in accord with some of the government guidance, suggests that the customer may still be required to pay for a service during a period of suspension. I don't think many will, but I think it's something that's worth asking for. And certainly with public bodies, the government is suggesting that's a good way to keep the economy running. Next slide, please. And I'm just going to touch on consumer contracts. We don't primarily deal with consumer contracts, but we have one or two queries, and I think it is quite relevant. There's something called the Consumer Rights Act 2015, where most consumer law, statute law, is now located. And that contains a list of provisions that are prescribed, not allowed within a contract, relevant across the board. Colleges, for example, the Competition and Markets Authority have said that students are entitled to rely on consumer law. Leisure users, where of course facilities have been closed for a period of time, and even Boris Johnson's announcement yesterday doesn't allow leisure centres and swimming pools to reopen, so that's still ongoing. Well, within Schedule 2 of that Act, there's a prescribed list of unfair terms, and if you have those terms in your contract, the general assumption is they are not enforceable in law and they can be challenged, for example, by going to court, or perhaps action can be taken by a trading standards department against you. One of those is to alter the terms of a contract unilaterally without a valid reason. Another one is to be able to offer a different contractual performance than what has been contracted for. So I'm afraid you can't always rely on what's in your standard terms to say, well, you have to carry on paying for the service that we're not providing, because that might be unfair from a legal perspective. So do be aware of that if you have customers who are challenging your right to enforce provisions under the contract. It may not be enforceable. Okay, I hope you find that's useful. A bit of a whistle-stop tour, and now I'm going to pass on to Kirstin, unless there are any questions. I'm just having a look.
And I've got one question that I've noticed come through, I have some sympathy with this. It is relating to the guidance on responsible contracting, which says, is this realistic, and are we really expected to do this? And I think this is referring to the really pretty broad provisions in the guidance. What's your thoughts on that, Stephen?
It's a very good question, Jess. I mean, this guidance is a bit motherhood and apple pie, and everybody's being encouraged to play nice to each other. And you could argue that it's unrealistic. And I've had organisations saying to me, we simply can't afford to comply with this guidance. We simply don't have the money. Who do they think we are? I think the answer is it can be useful. And if you're faced with somebody that is perhaps being very legalistic and saying, you have failed to achieve your precise requirements in terms of KPIs, you can say, come on now. The government guidance is that you should give us a little bit of latitude. And I think it provides a little bit of moral authority. And certainly when we've been giving opinions to clients about contracts, we've said, you should draw attention to this guidance. It might just make businesses, want to have a good sort of corporate social responsibility approach nowadays. It might just persuade them to be a little bit more tolerant in terms of enforcing. We know a lot of people like landlords and funders are showing a degree of tolerance at the moment because they're having to. But yeah, it doesn't have force of law, it's only guidance. And I think another question has just popped up. Just saying thank you. Oh, well, thank you. Okay, over to you, Kirstin.
Thank you, Stephen. So, Jess, if you could click through to the next slide. So these are just some practical steps for things you should be doing now and turning our thoughts towards the future. So the top one is cash collection, although it's ridiculous for lawyers to talk to businesses about cash collection. The reason I put it there is really to urge you all not to let things, not that you would necessarily be letting things slide, but you're going to have to be tighter than ever on cash collection because of the provisions which Jess has mentioned and the guidance that Stephen has talked about. So some of the remedies that would usually be available to you where your customers aren't paying just won't be. So most people would be doing credit checks before they take a customer on, but perhaps repeating those, keeping an eye on, if it's the type of contract where there are service credits that you can enforce against a supplier, for example, or that a customer can enforce against you, or if there are KPIs. All of those are going to be more tightly monitored now, and you might want to, subject to what the guidance says and how you feel about the guidance, be enforcing rights which normally you might have just been more relaxed about. A good idea, particularly when a customer comes to you and asks for extended credit terms, is to have a playbook ready so that you and your management team have thought about how you're going to respond to each customer. It's a good idea to do this so that you're having consistency across your business in terms of the response, but also so that you've got all your good ideas in one place. And such good ideas could include always ensure that you're reflecting back to that customer in writing the length of the variation to the contract in terms of the credit terms, that you've bookended it, rather than that being a variation which rolls forward once coronavirus has all been done and dusted and behind us. Not that that's ever going to happen, but so that there is a limited time when you're allowing your customer to pay on extended credit terms, as opposed to it being a variation which applies to the contract forever. Another idea is to think about, if your customer's coming to you because it wants extended payment terms, is there anything that you can get in return? So if there was something that you didn't manage to negotiate into the contract at the time you formed it, maybe now is the time to ask for that. Similarly, if it's a supplier coming to you saying, we can't deliver on time, we'll be late, or some of it will be late, you might want to see what you could ask for in return for that. So it might be, I had one client where suppliers were delivering inventory late, but when it arrived she was having to store it, but her customers who were outside the UK couldn't take it off her hands. And so she negotiated with suppliers, well, yeah, you can deliver late, in a legal sense, but actually, can you store it for me? And I'm not paying for that storage. So what can you get out of people in return for your flexibility? Responding to force majeure, I'm not going to deal with this in detail because Stephen already has, but don't necessarily roll over. So if it's your supplier or indeed your customer coming to you to say, I can't comply with my obligations because of force majeure, firstly check that there's even a clause in the contract dealing with force majeure, because if there isn't, as Stephen said, there's no default position under English law that it will apply. It's only going to apply if it's in the contract, and the extent to which it will apply will be as stipulated in the contract. So, again, another client was having customers saying we can't pay because of force majeure, and her response was, nonsense, you can still press the payment button, so please press it. So you don't necessarily have to roll over. Having said that, you don't want to ruin your business relationships going forward, which is why lower down in the slide I mentioned open without prejudice letters, which are very sort of solicitor thing, but you can use them to your advantage. So, for example, if somebody wants to use force majeure against you, you can respond in an open letter and say, nonsense, doesn't apply. But in order to maintain that relationship with the client, you can head up a letter and an email without prejudice, which means your offer of settlement can't be used against you. And in that settlement letter, say, right, we've been in business for years, so let's see what we can do. But as I say, it just means that that offer of settlement can't be used against you as a sign of weakness in your actual position. I mentioned business continuity plans, disaster recovery plans. If those are relevant to your contracts, you may have had an obligation to put one in place, say, 6 months after commencement date. That's a usual provision. They're often not in place at the date of contract. Sometimes they are, sometimes they aren't. And then coronavirus hit us like a hammer, and lots of businesses found that they'd never actually put the business continuity plan in place and were rushing to write them. So now we've got a little bit of breathing space. Maybe now's the time to go back and revisit that and think about that rushed plan. Maybe now I need to have a look at it again. Is it still working? Government guidance changed again yesterday. Is it still working? Do I need to vary it? And this probably is the most important bullet point on the slide, record all your variations in writing. An email will do, but a phone call, two people will walk away from a phone call with different ideas as to what was agreed. So always follow up phone calls saying, great, what we've just agreed is, and put it in writing. And then if ever there's a disagreement later, you've got it there and you've got your evidence that you can produce. Jess, can I have the next slide, please? So lessons learned and how to improve things for the future. Not all businesses, but some businesses are sort of having a moment now before second wave hits. It's coming. rethink what they're doing right now as business gets back to the new normal. Force majeure clauses, Stephen has said, amend them if you can. So that will be a variation in your existing contracts, or thinking about how you want to change it in your new contract. Whether you want force majeure clauses at all depends on whether the contract is one where it's going to be used against you, somebody else saying that they don't have to perform their obligations because they're suffering a force majeure event, or whether you will want to use it against a supplier. But one thing, if somebody's going to use it against you, be that a supplier or a customer, then look at including words about foreseeability, because what you don't want to do is sign a contract today with the new pandemic wording in it, and tomorrow the customer or the supplier phones you up and says, oh, we're suffering force majeure. So it has to only be force majeure events which weren't foreseeable at the date you entered into the contract, and even a second wave is foreseeable now. Express rights to suspend services deliveries, options to terminate for non-payment. Again, this is subject to what Jess has already said. You won't be able to use this whether the company has, or the business in question has successfully applied for the moratorium status, or if it's due to an insolvency. And it's also subject to what Stephen said if you're deciding to comply with the guidance. But where you can get it, it's very useful if you do have these express rights, because otherwise you're looking, your customer stops paying, and then you're looking at your termination rights. And most contracts, not all, but most contracts would give you a right to terminate for material breach. But how many mispayments constitute material breach? Then you're in a sort of can I, can't I situation, and you don't want to be on the wrong end of serving a notice of termination where you weren't allowed to do so, because then the other party sues you. As I've mentioned again, second wave, prepare for it, think what you need to do. Grey areas. One thing I wanted to mention is that at the beginning of lockdown, in a way, life was easy, awful, but easy, because the government had said we all had to stay home. Now we're in a situation where perhaps your customer is expecting, if you've got the kind of customer contract where you have to, for example, send your staff to the client site to perform the services, your customer is saying force majeure, if it ever applied, no longer does, send your staff please. But you're looking at the health and safety provisions in the contract and thinking, that's not enough to protect my staff from coronavirus. And therefore we are in a real grey area as to what parties are obliged to do to fulfil their contracts. They might be contractually obliged, but feel morally that they can't send their staff into that sort of situation. And there are going to be a lot of disputes resulting from this area, we think. And then finally, thrash it out. When you are able to vary your contracts, and certainly in relation to new tenders for new work, really have a helicopter view of what extra costs are you going to be incurring in the new normal, extensions of time that you might have to ask for further down the line if there are further waves, further lockdowns, other complications as a result of COVID-19 that need to be addressed. Now's the time to be thinking about them. And as I say, if you are in the lucky position of being able to vary your contracts, and certainly if you are able to negotiate them into new contracts, be thinking of these things now. Thank you.
Great, thank you, Kirstin. We'll now move on to general Q&A. As I said before, if anybody wants to ask any particular questions, do drop them in the Q&A box. I've got a couple for you guys to start with. So, Kirstin, I think this is probably a question for you in the force majeure points. Someone's asking, what can I do if I can't supply a customer in full due to supply chain problems, but can deliver part of what they're ordered? And is that covered by force majeure?
It's going to come down to what the exact wording in your force majeure clause is. Some force majeure clauses say that you only escape liability for failure to perform your obligations where you absolutely 100% can't perform your obligations. So in that circumstance, you'd be a bit stuck, I'm afraid. Some force majeure clauses, however, use the word hindered. That's a common word, and that would assist you. So if you are hindered, then to the extent that you're hindered because of the force majeure, you would escape liability for that element of it. So it really comes down to reading the words and how expressly what you can and can't do if affected by force majeure is set out in your contract. And I would also add that if you're in breach of contract because of things which have nothing to do with the force majeure event, perhaps you weren't able to supply anyway, and actually coronavirus hitting in some respects therefore has given you a bit of a get out, then the force majeure won't protect you in relation to breaches which are not as a result of the force majeure event.
Okay, Thank you. Stephen, did you have anything to add on to that, or should I move on?
Yeah, but I was just thinking, it is quite a commonplace situation. It used to be said, I don't know if it's true, that Marks and Spencers would say if you wanted something to come in a box of 25, if you supplied 24, they will reject the entire consignment. I do feel, although what Kirstin said is right in terms of black letter law, when we do start disputing these things and going to court in a few months' time, I think people are going to get quite short shrift from the system if they are saying, because of this very, very minor failure to comply precisely with the supply requirements, you're in breach of contract, or we're going to reject all the goods. I think there's probably recognition there needs to be a bit of tolerance. And, and if you're getting supplies, if a supplier can supply most of what you want, but not all of it, then isn't that better than getting nothing at all? I think this has got some way to play out. And I think, as Kirstin says, it's going to be very interesting if we do see litigation, and there are bound to be disputes, what view the courts will take. And there are some strong public policy arguments that the traditional sort of pedantry of being precisely in accordance with all the details of the contract. There's probably quite a one-sided contract that's been written by one side or the other anyway, whether it's appropriate to enforce those things. And it's going to be difficult, interesting to see the way that in which the courts try and get round this situation. I suspect there'll be a bit of creative work by the judiciary when we see these things in court.
Yeah, and I think, I suppose, to add to that from my point of view, and I think this goes back to something Kirstin said, there will be a lot of these issues that go to court and that will involve people having to argue them in front of judges. But I think there will be probably a considerably larger amount of these things that are dealt with between the parties, and to an extent, regardless of what the contract says. And actually, I think there's a lot of businesses at the moment that are really focusing on sort of more the crisis management, more the collaborative approach to get out of sticky situations with everyone's businesses still intact, because you don't want to put your customers or your suppliers out of business because you're going to need them 6 months, a year down the line. So I think that there is going to be a bit of both, I suppose, a bit of things going down more the court route, but also I think people are going to have to do what I kind of refer to as not waiving the contract at people, because you are going to need to work together a bit more, I suppose, at the moment.
And of course, for those who aren't litigators, litigation is quite expensive now. The cost of actually issuing legal proceedings has gone through the roof. The court system has become self-funding. So, if you're faced with the choice of paying £10,000 just to issue the claim form, let alone the cost of your barristers, etc., it make a lot more sense to try and mediate and resolve that in an informal way.
And that actually goes back to what I said about the ability to apply to court for being able to enforce termination clauses if a business is in moratorium or insolvency. If you are going to suffer hardship to continue supplying, there's going to be a real balance there between, is the hardships insignificant enough that I need to almost throw more money throw bad money after good to get a court order to enforce that, or am I better off just continuing the supply and hoping that it doesn't go too wrong? I think there's going to be a real balance there.
Yeah, I agree with all of that, but just for our watchers, I think our litigation team is the busiest team at Freeths at the moment, so there is already a lot of litigation coming out. But the only ones who win when there's litigation are the lawyers. So if you can use your open without prejudice letters or agreeing variations to contracts and then record it in writing, that's going to be a better result for you, because then you'll have business relationships at the end of this.
Absolutely. I've got one more question here, which goes back to this point about the termination for insolvency clauses and the ability to not use them, which just says, isn't this really unfair on suppliers? And again, I have some sympathy with that point. It is going to be something quite difficult for suppliers to deal with, but I think the background of that is it's a measure to try and keep businesses in business. And it's significantly detrimental to a business that's potentially in administration, is capable of rescue, for it to suddenly lose all of its supply chain. And I think that's what the government is sort of aiming at with all this, is to try and give businesses more of a chance. Excuse all the noise outside my house. I have people on the roof with ladders. Hopefully you can't hear too much of it. It's to give businesses that chance of recovery that might not otherwise be there if all of the suppliers were to withdraw their supply. So I think, yes, it is a bit harsh on suppliers in a sense. But the broader picture is that this is intended to help the economy, help businesses stay in business, all that kind of thing. Does anyone, any of the other panelists have any thoughts on that?
I suppose for me, it's just that it pushes the problem up the supply chain. So, you know, if it's a supply chain with lots of suppliers to customer to supply, you know, just pushing the problem up. But, you know, we are where we are. We've had another question in. We have a situation where we need to send engineers to complete our contract in Europe, but do not want to due to quarantine upon return. I don't want to read the whole question out. We are able to send them as they're in. So basically, there's a problem about sending staff abroad, and I suppose this falls into the grey areas that I was talking about, and where essentially you need to go back to the exact terms of your contract and see what rights you may or may not have, and picking up what we've just said, have a sensible conversation with the customer as to what is and isn't possible. But we can pick that one up with you afterwards, as you've suggested. It's quite detailed.
Going to add, Kirstin, I was looking at the guidance I was talking about. One thing that does talk about is requesting and allowing compensation for increased cost for additional performance. I mean, we've certainly seen people say in the construction and FM sectors saying we now have to provide PPE for our employees, perhaps disposable PPE on a daily basis. We now have to have our employees working 2 meters apart. So, you know, it's going to be harder to do the job. And we've had people that have been negotiating additional amounts of money within the contract for that compliance purpose. Now, in this case, it may be you have to say, because we have to quarantine our engineer on his return, we want some additional money because that employee will be useless to us for a while after he or she comes back to the UK. And I think that's something that is perfectly reasonable to suggest. And it's in line with government guidance, which we said before, you know, isn't but letter law. But I think, you know, you can say to your foreign customer, well, to comply with UK guidance, we're going to ask you for some additional money to deal with this issue. And, you know, that's the basis upon which you can have, as you say, perhaps a discussion.
It'd be worth finding out as well whether there's similar guidance in other European countries that you could quote back at the customer.
Yeah.
And I think again that also comes back to this idea of people aren't going to want to put their customers and suppliers out of business to an extent. You know, people are going to have to be understanding of these things, and if what was going to be normal business is actually going to incur additional costs, there's a bit of a kind of, you know, sharing the pain on those kind of things. I think that's going to need to be involved. Obviously that's all down to your business relationship and how the parties work together and how understanding the parties are, and I think, as Stephen says, pointing back, even if that's not, even if it doesn't have the force of law, it's still a tool, I think, in that discussion. Cool. Okay, I think we've reached the end of the questions. So unless anybody has any last minute questions that they want to drop into the question box, or unless Stephen or Kirstin, you've got anything. Oh, I'm just jumping on with the slides. Unless Stephen or Kirstin, you've got anything you wanted to add on any of those points.
Maybe we just ought to say that obviously where we are, there might be some things that are confidential. You don't want to be in this forum. There might be something that's not all fours of what you've heard today, but obviously we are happy to help, and we generally don't start charging you until we've agreed to open a file. So the tax start running the minute we pick the phone up, honestly.
So it's worth saying we will send a follow-up email later today to everyone who's attended, with a link to the slides from the session and also our contact details if you want to get in touch with any of us and follow up on any of these points that we've covered. We're also recording this session, so you'll get a video link, I think, in a few days, if you want to watch it again, if you want to share with colleagues, etc. On the impact on your business of the rapidly changing legal landscape that we're finding ourselves in. You can find a lot of information on that in all sorts of areas on our coronavirus hub, which is on the Freeds website at freeds.co.uk/coronavirus. Otherwise, thank you to everybody for joining us today, and we look forward to seeing you again next time.